Bankwitz on behalf of Mr. Boone. Judge, I believe I said in my motion attorney number 7, but I think I was actually attorney number 6 on the case. I've had the case the longest of the three of us that are appearing before the court now.
All right, thank you. And Mr. Hobson, you were court appointed to Ms. Boone at some point during her saga as well?
Yes, Your Honor. After Mr. Bankwitz withdrew, I was appointed.
All right. So we have all three of your bills, and I know JAC had indicated they had no objection to Ms. Cashman's bill, but I did not get a similar statement with regard to Mr. Bankwitz or Mr. Hobson, so I thought I needed to have a hearing with all three of you present. I am...
Right.
Mr. Lake?
I was going to say, Your Honor, there is an objection here because essentially what we're at this point is this is compensation in excess of the flat fee because there's 3 attorneys involved. So there's no line item objections per se because these are all flat fee bills, but we're basically objecting on the basis that the total compensation here is going to exceed the flat fee to some extent. Right.
And I will tell you that I am very familiar with Ms. Boone's case because she has gone through many attorneys and has, according to Judge Kranick's order, sabotaged those relationships. And accordingly, attorneys needed to withdraw and new attorneys were appointed. And I do recognize that a lot of work was done for Ms. Boone. So we will start with Mr. Bankwitz, then move to Mr. Hobson, and then to Ms. Cashman.
Thank you, Your Honor. Basically, I had the case for a little over a year. I had 175 hours in the case, including actual 45 hours at the jail with the defendant. When I received the case, I got a box of crazy information, I'll put it that way. And it was an entire file box, and it took weeks to go through it, categorize it, and kind of figure out what was going on in the case at that point in time. She originally had a privately retained attorney, and I basically received his case and his file because all of the other court-appointed attorneys before me, I believe, had waived any attorney's fees, and because they did basically nothing on the case. The three of us did a lot of work in the case. As I said, I put in 175 hours, and even at the $75 an hour compensation, we're looking at $14,000. Spent a lot of time with Ms. Boone and a lot of time on the case. So I'm requesting a flat fee in this case.
All right, thank you. Mr. Hobson.
Good morning, Your Honor. Good morning, everyone. Your Honor, I got the case from Mr. Bankwitz, and I got the same information. The information Mr. Bankwitz just recited that he had and reviewed, and in addition, of course, his information on top of all of that. I spent some time with the defendant at the jail. I spent a tremendous amount of time with the investigator reviewing the case, talking about discovery, experts, and so forth. I spent a tremendous amount of time with a proposed expert, Dr. Linda DeRay. That it turns out the defendant didn't like her. I thought she'd be great. We talked for dozens of hours, almost daily, extensive periods of time, coming up with theory of defense or theories of defense. In fact, you combine the information from the expert, the force attorney that was privately involved and took the case to right up to the edge for trial and then had to back out. So I had that information, those boxes or box of information Mr. Bankwitz talked about. I had those, I had to go through those. I gave all that material to Ms. Cashman plus my information on top of that. Spent a lot of time interviewing people about how they'd respond if they were jurors, So I was looking at the case from all angles. I had the case from, I believe, September 23 until May 24. I would say conservatively, any lawyer that had this case can tell you easily they spend at least an hour to 2 hours on this case every single day. Given the information coming in from Ms. Boone, the matter she wanted dealt with, her theory on the law versus our theory on it was a constant battle going back and forth. And you had to deal with the gaslighting. Um, and I told Judge Kranick at the time that I withdrew that it's just was too much. This case required at least 2 lawyers. I told that to Judge Kranick, plus possibly an assistant. I see now the case has 3 lawyers, plus experts that we worked at getting, plus investigators. So everything they're doing now, we attempted to do. We made every effort to do all those things. Ms. Boone now has custody of files belonging to myself, Ms. Cashman, and Mr. Bankwitz. We did just put in a tremendous amount of work. It taxed every fiber in your body and the bodies of the assistants or any person that worked with you on this matter. And I think flat fee for each of the attorney would be exceedingly reasonable, Judge. And I heard the judge comments regarding $75 an hour. I won't even speak to that. It would be totally redundant given the expert knowledge of all the attorneys and Your Honor involved in this case and any other case we come to the court on regarding fees. But this was a extremely difficult case, Judge. Most of the difficulty revolved around just handling the defendant and coordinating the defendant's thoughts on how things should go with what our experts were telling us and our investigators were telling us. So I believe the flat fee for each attorney would be anything less than the flat fee would be totally confiscatory, Judge. Thank you so much.
Thank you. Ms. Cashman.
Your Honor, I'm asking for the $15,000 flat fee, and I'm also asking to be reimbursed for the $1,800 that I paid to an expert, and JAC has a copy of my check front and back on this case. One of the issues that always has to be addressed when there are multiple attorneys, and I was the 8th attorney and the 4th private court-appointed attorney, is making a case that is old by purposes, for reasons of being on the docket for a long time, a priority, and putting aside other work. One of the unusual things about Ms. Boone's case was when I did withdraw for ethical reasons, the court found that she had forfeited her right to an attorney. She is charged by information with second-degree murder. There was an unusual amount of media attention on this case. The facts are she's accused of putting her boyfriend in a suitcase. He later dies. There is a video of this that went viral. Because the video went viral, because of coverage by Court TV, News Nation, Fox, the local channels, the Sentinel, and websites such as Know Your Lawyer, Legal Bites, and Bruce Rivers, you had to review not just the banker boxes of discovery and work done by the previous attorneys, but stay up to date with what potential jurors were viewing if they were watching it on the internet. There was a lot of correspondence between the defendant and the court. Obviously, I had to review all that. The most recent piece of correspondence when I was Ms. Boone's counsel was the 58-page letter that she wrote. And again, all these letters are published, they're analyzed. I like previous counsel, spent an inordinate amount of time with Ms. Boone. I spent over 20 hours during my period of time that I was representing her. I believe that for multiple reasons, the court can find that this case was extraordinary and unusual, and that it would be confiscatory to not pay me the flat fee. And having provided the requested proof based on the procedure for reimbursable costs, it's my understanding that Mr. Lake is not objecting to me being reimbursed for the $1,800 that I spent to retain an expert who did not have a contract with JAC.
Thank you. Mr. Lake?
Yes, Your Honor, just briefly. As far as the issue of the $1,800, JAC has no objection to that reimbursement. That's more of a technicality. The court did approve the expert. This is just the attorney getting reimbursed for expense that we have no objection to. So that's a non-issue. But you see that in the order. As far as the fees are concerned, the issue here is that other than Ms. Cashman, who submitted an hourly statement of 118 hours, none of the other attorneys actually submitted hourly statements, so we are kind of constrained by the statute. The problem is the statute only allows up to 200% of the flat fee in the absence of hourly statements. In other words, the way that the statute is worded very unusually, but essentially what it says is the court can award up to 200% of the flat fee without, and then it can only go above that if it finds that the case is confiscatory, and then can compensate the attorneys at a rate of $75 an hour. So that's where we get into a little bit of a difficulty here, because double the flat fee here would be $30,000, which is less than each of the attorneys is requesting $15,000 each, would be $45,000. As far as, and at that point, looking at the statute, what we have is Ms. Cashman, she got 118 hours in. That would represent at a rate of $75 an hour, $8,850. Based on Mr. Bankwitz's statement, he has 175 hours in, which would be $13,125 at that rate. And Mr. Hobson, he just basically said about 200 hours, which would be $15,000. That's the issue, Your Honor, is that, I mean, technically compensation has to be at a rate of $75 an hour for it to go above $30,000. And so beyond that, I mean, ultimately, but we leave it to court discretion to determine reasonable fees for each attorney, and we acknowledge that this, I don't think we can even begin to dispute that this is not an extraordinary unusual case. It's just that what the statute says is how the compensation structure is set up, and we have to argue that the court needs to follow that structure.
Mr. Lake, if one bills hourly, can the others be flat fee under your interpretation of the statute?
That, until you get to double the flat fee, yes, that works. But once you go above double the flat fee, then at that point, it really should be compensation should be $75 an hour. However, we also acknowledge that we have had other cases like this where the court has awarded the full flat fee to each attorney, and we've never taken it up. So I mean, it's essentially, we have to argue that you can only go to 200% of the flat fee, and at that point it has to go hourly. But we also acknowledge that realistically, there is no attorney on the case, other than somebody who might take the case pro bono for other reasons. There's no attorney on the surface of this planet that would take this case for $15,000. Your Honor, if I may address.
I don't need to do that, Mr. Hobson. Thank you.
Yes.
I am going to award the $15,000 flat fee to Mr. Bankwitz and Ms. Cashman, and a $15,000 hourly fee to Mr. Hobson. Ms. Cashman will be reimbursed her $1,800 in costs. I will issue an order to that on each of these cases. You've sent me orders electronically, and I will e-sign them. I've got it here. And e-file them in just a moment. Mr. Lake, do you have any questions?
No, Your Honor.
All right, anything further with regard to this matter?
No, Your Honor.
Your Honor, I would just state that I'm not asking for this cost, but I paid over $400 in photocopy fees costs, for material that I sent to Ms. Boone along the way. But I'm not asking for that to be refunded to me.
All right. Thank you, Mr. Hobson.